Thank you, Mr. Chair. And let me, first of all, on behalf of the Secretary General of the Council of Europe and its Special Representative for Roma issues recently nominated, Mr. Schockenburg, to thank the organizers for the kind invitation, in particular FRA and also the Czech presidency of the decade for having chosen this important topic of housing, which is often less discussed than other topics such as education or health, because it's a rather problematic one. Let me start also by recalling for participants a number of standards developed by the Council of Europe in the field of housing, and in particular Roma housing, and namely the jurisprudence and decisions of the European Social Charter and the European Court of Human Rights. At Council of Europe level, the European Social Charter and revised Charter, and in an indirect way, the European Convention for the Protection of Human Rights, contain important housing and housing-related rights. The Charter grants rights to social and medical assistance for those without adequate resources, establishing housing obligations in relation to physically and mentally disabled persons, children and young persons, migrant workers, elderly persons, and rights to social, legal, and economic protection for families, including a state obligation to provide family housing. Part 5 or Article E of the Charter states that the enjoyment of the rights set forth in the Charter shall be secured without discrimination on any ground. Article 30 on the right to protection against poverty and social exclusion includes an obligation to promote effective access to a range of services, including housing. Article 31 directly establishes a right to housing, with contradicting states undertaking to take measures designed to promote access to housing of an adequate standard, to prevent and reduce homelessness with a view to its gradual elimination, and to make the price of housing accessible to those without adequate resources. The Social Charter, the Committee on Social Rights, indicates that, in fact, to imply that this application of Article 31 implies that state parties must adopt the necessary legal, financial, and operational means of ensuring steady progress towards achieving the goals laid down by the Charter, maintain meaningful statistics on needs, resources, and results, undertake regular reviews of the impact of the strategies adopted, establish a timetable and not defer indefinitely the deadline for achieving the objective of each stage, and pay close attention to the impact of the policies adopted on each of the categories of persons concerned. Recalling our yesterday's discussion in Rudnice and Adlabem, I would like to highlight a few aspects of the Charter. Even if under domestic law, local or regional authorities, trade unions, or professional organizations are responsible for exercising a particular function, state parties to the Charter are responsible under their international obligations to ensure that such responsibilities are properly exercised. Thus, ultimate responsibility for policy implementation involving at a minimum supervision and regulation of local action lies with the government, which must be able to show that both local authorities and itself have taken practical steps to ensure that local action is effective. A few words about the European Convention on Human Rights, which contains many civil and political rights provisions which are being indirectly interpreted in the development of housing rights across Europe, especially with Articles 3, 6, 8, 13, and 14. In Moldovan and others versus Romania, the European Court of Human Rights concluded that the applicants' living conditions and the racially discriminatory manner in which their grievances were handled by the public authorities constituted an interference with their human dignity, amounting to degrading treatment with the meaning of Article 3. Article 8 protects the rights of individuals to respect for their private life, family life, and home, although this does not amount to a right to housing. Positive obligations on states to protect people's home have also been founded under Article 8 in relation to protection from smells and nuisance from a waste treatment plant, toxic emissions emanating from a chemical factory, or environmental pollution from a steel plant. I have to say that Article 8 was also used recently by French courts to stop evictions of Roma families, even if they were illegally on illegal informal settlements. Apart from this very important legal framework, I have to recall that the Committee of Ministers for all your countries are part of have adopted a number of recommendations concerning specifically Roma, and namely a recommendation on housing, and another one for the Western countries which have still a nomadic population. The recommendation 2005-4 on improving housing conditions of Roma and travelers in Europe contains, in fact, very concrete 52 provisions which cover the wide range of aspects of the housing policy and measures. It also includes a definition for the purpose of the recommendation, and the definition is housing includes different modes of accommodation such as houses, caravans, mobile homes, or halting sites. So it's a large definition, and especially for traveler and itinerant Roma, it's important that the caravan is considered as a housing as well. I would like also to recall some of the viewpoints by the Commissioner for Human Rights, Mr. Hammerberg. As you may know, he made first of all recommendations in June 2009 regarding especially the right to housing. And these recommendations reiterated a number of conclusions he made in his paper, Housing Rights, the Duty to Ensure Housing for All, which I invite you to consult and which dates from April 2008. In this report, it of course recalls the Social Charter and European Convention on Human Rights Principles. But because we are in a session also to exchange practices, I just would like also to identify a number of interesting national initiatives taken in the field of housing and mentioned in this report. For example, the Homelessness Scotland Act from 2003, which obliged local authorities by 2012, so next year, to secure adequate accommodation for all persons who become homeless as part of a legally binding obligation to provide housing for all. The question of intentional homelessness and local connection, which limited eligibility in the past, will be removed. This represents a major development in universal and enforceable housing rights in Europe. Also, the recent law on the justiciable right to housing in France aims to give people the right to seek legal redress before an administrative tribunal where their right to housing has been avoided by public authorities. It can require the state to offer the claimant adequate housing within certain categories or needs. Spain as well has interesting practices, since several autonomous regions are currently discussing ways to enforce housing rights for vulnerable groups. In Andalusia, a new law aims to ensure access to housing for 3 different priority groups: people with an income that is below the minimum wage, socially disadvantaged people, and young people. It will be enshrined in Article 25 of the Regional Constitution of Andalusia. And in Catalonia, the National Pact for Housing aims to ensure that nobody experiences housing exclusion due to economic reasons. The Catalan government will use elements of the Scottish and the French law in the prevention of homelessness, prevention of eviction, and support for tenants. Finally, let me say recall as well that one of the main problematic when we are dealing with housing policies is not only to implement good measures and afford housing, but also the other part is to stop evictions. And the Council of Europe has raised on a number of occasions the increasing number of evictions taking place in member states, particularly between states, but also at local level. And of course, this requires that if we really want to have an affordable and efficient policy in the long term, evictions also should stop. Otherwise, it just creates a problem elsewhere and particularly for the municipalities which are trying to have efforts to integrate the Roma populations. In order to comply with Article 31 of the Charter, the legal protection for persons threatened by eviction must include an obligation to consult the parties affected in order to find alternative solutions to evictions. It's one of the points, but I thought it was important to raise. The other aspect I wanted to mention before the end of this presentation was to recall that the Council of Development Bank can also provide loans for housing projects. It has done so in the past in Bulgaria and Hungary, and your countries are very much invited to contact the bank for having such loans for housing projects. I also, because it was mentioned, the importance to raise awareness among population. In the context of the DOSTA campaign on awareness raising against prejudices and stereotypes, the Council of Europe Congress for Local and Regional Authorities also organized a prize for municipalities having positive and good practices in the field of Roma integration, and housing would certainly be one of these aspects. And let me conclude my presentation by quoting the Spanish Ministry for Housing, which was submitted in one of the papers distributed in our committee of experts. A house is not only a material good, it is also many other things. It is our second skin, it is a space for our memory. It is sometimes the unique stable reference when everything changes around us. And it is of course something necessary for any project of life. I thank you for your attention.